Yeah, I just realized I was on mute. So, hi, welcome to another drafting session. And today we are going to talk about trademark licensing agreement. So, what exactly is a trademark licensing agreement? When you talk about licensing, it means basically giving something on rent. So, just how you would give your house on rent, you also give your IPR. Your IPR is a very valuable property. For every business owner, your IPR plays a major role in increasing the assets of your company, in increasing the valuation. So that is why if you want to use the IPR, transfer it, you want to, uh, you know, you want to expand your business, using an IPR wisely is something that is recommended. Hi, good afternoon. So we'll begin with our session. Now, what exactly is a trademark licensing, or why would you opt for trademark licensing? Basically, it's nothing but the permission by the owner of the trademark, that is the licensor, to the licensee to use the mark. Here, the ownership remains with the original person. When we are, talking about today's session, all you need to do is think about some big brand, let's say like Reliance Retail, McDonald's, etc., which allows franchisees. So what happens in the franchisee model is you give permission to another company, another individual to run a shop or an outlet on your behalf. Okay. So just think about a franchisee model when you are attending this session. Now, ownership basically remains with the license. Even though McDonald's has given a lot of its outlet on, rent, or a lot of outlets are franchisee based, the main logo or the main IPR of McDonald's remains with the parent company, which is registered in the US. Okay, so basically, this license agreement is nothing but the commercial exploitation. The trademark agreement is nothing but the commercial exploitation. Okay, and it usually also includes a royalty or a fee. So when you are giving your agreement or your IPR on rent, you usually have a royalty or certain amount of charge which is applied. Okay, so the basic confusion which a lot of students have is that is licensing and assignment same? No, licensing and assignment is not same. Both are entirely different concept. There are few key similarities. Apart from that, it's entirely opposite of each other. Now, licensing is you give somebody to use. For example, you have a house which you give on rent for somebody to stay. Assignment is you are transferring the ownership temporarily. Now, licensing, it basically allows you to transfer, but you don't transfer the ownership. You just share the exploitation rights. So let's talk about what are the governing laws for trademark licensing. So you have your Trademarks Act, which is the parent act which governs the entire licensing. Section 2(1)(r), which talks about the permitted use. You have your section 28, which talks about right of the registered proprietor. Section 48 deals with use by a registered user. Section 49 deals with registration of the registered user. 50 talks about variation, cancellation. 53 deals with rights of permitted user. Now, trademark licensing is basically recognized through the registered user concept. That means only a person who is a registered user can have certain more rights. He will have more rights than a person who has been using the same trademark for many years. Now, you may wonder that why am I teaching you the theory? Many people may already be well aware with the theory, but one major mistake I have seen a lot of lawyers do is they don't know the law while they're drafting an agreement. Even today, when I draft an agreement, I first read the law. What does the legal provision say? Because when you are drafting, your drafting skills are only 10 to 20%. Remaining 80% is how you negotiate and convince your client as well as the other client according to the legal, staying within the ambit of the legal provision. That law has permitted XYZ, law has permitted this rights. How can I ensure that my client can exploit these rights? Because if you say in a contract that, I don't want XYZ rights, then even if the law says that, this is your given rights, you will not be able to protect your client. So knowing the law is very important before you even proceed with your legal drafting. So there are different types of trademark licenses which are available. One is exclusive license, that is you will give your license only to one person, only he can use. Even the owner may not be permitted to use. Many a times it happens, a lot of people register their trademark and they just give it to others on license. The reason why people do it is because trademark registration takes a lot of time. So if you have an already registered trademark, you can give it on license to one exclusive person, but then that also means that you will not use it for yourself. Okay. Then comes your non-exclusive license. For example, in case of multiple franchise agreement. So when you open franchisees, you have to give multiple licenses. Okay, trademark licensing. You have the sole license. That is again similar to your exclusive license. You have only one licensee, plus the owner retains the right to use. That is, there is an exclusive license that you have given, but then apart from that person, even the owner can use the trademark license. If you have any queries, you can just drop them in the comment section. I will address. So let's talk about what exactly is the difference between a registered user and a permitted user. Now, registered user is someone who has registered the trademark with the trademark office. So by law, by default, they have got certain rights which is going to protect them. They can also sue. Now, a person who is a licensee cannot sue in case of trademark infringement. And a permitted user is basically the licensee, someone who has got a license to use a trademark agreement. They are someone who is not registered. They have very limited rights with respect to trademark infringement, and they cannot sue independently. Okay. Now, does this trademark licensing, does it require transfer of trademark? Licensing means giving on rent. So the direct answer is no, you don't require. Now, licensing, it does not transfer the ownership, and the trademark, it always remains with the licensor. Only the right to exploit or right to use for a certain purpose is what is permitted. It is not assignment. It is not sale of a trademark. Now, suppose there is a hotel, something like a Ramashray, which has been having an outlet in Mumbai since like almost 50 plus years. Okay, maybe they did not register a trademark. Now they want to open another branch, but they'll be doing it either through franchise model or partnership or something like that. But they have to give their trademark to be used, because until and unless you don't have the same logo, you don't have the same brand vibe, the brand name that is used in your fellow hotel, you will, people are not going to relate. So yes, an unregistered trademark can also be licensed. Now, why is this permission granted? Because common law trademarks can also be licensed in order to avoid the passing of rights. However, you cannot record this agreement with the registrar, and you will have very less statutory protection. So you will register, you can have a license agreement, but the legal protection will be very less. Now, what are the clauses that you are going to use apart from your standard clauses like parties, scope of work, etc.? These are a few clauses that you're going to add. So one is the grant clause, which basically talks about your scope of license, whether it's an exclusive, non-exclusive, what is the territory. Now, is this a franchise that is going to be opened only in Mumbai? In Mumbai, which area? So why you need to mention is because if I'm entering into a franchise agreement, it means I can use the logo on all the creatives that goes on my social media. I will use it in my physical store. So where all can I use it? Now, if I open a franchise again in, let's say, Gurgaon. So in that case, I need to enter into a fresh trademark licensing agreement. This agreement will not be valid. What is the term of the license? So usually how much duration you have for your trademark register for your franchise agreement, that is the duration for your license. What is the fixed percentage? So just like you pay rent, you will have to pay royalty. So what is the fixed percentage of revenue? Why is it mandatory to protect the brand reputation? Okay, you need to have good quality control. So how you will have brand protection is, let's talk about McDonald's or your Ramashray or what is that, Rameshwaram Cafe. They all have certain ingredients which gives them, they're all food outlets, and they all use certain ingredients which gives certain taste, certain quality to their food. Now, it is the duty of the person who is taking the license or who is opening the franchise to ensure that the same standard is maintained. So in order to maintain the brand reputation, the quality control has to be considered. You have to talk about the usage guidelines. Not a single inch here and there you can meddle, or you can mess up with the logo, the coloring, the packaging, or branding. You also have a sub-licensing clause, that is, you cannot give the outlet on sub-license. Indemnity, there is trademark clause, termination clause, etc. So this is in short on what you will have in this agreement. We'll do a more detailed agreement later in the session. Again, you can add these few additional clauses. That is, of course, you have your confidentiality, IP ownership, inspection and audit rights. That is, the main licensor, he can always have inspection and audit rights. You have advertising and promotion guidelines, non-compete clause. You have your dispute resolution. What happens if there is dispute between both the parties? What is the governing law? Is it going to be the city in which the franchise has been opened, or is it going to be in the city where the original licensor is residing? Now, remember one thing. A good agreement is completely drafted on the basis of how well a lawyer negotiates for this client. There is nothing called as a good agreement or a bad agreement. It's on how well you can convince your the other side in getting the rights in favor of your client. Okay, so negotiation is a very important skill that one needs to learn before you even learn drafting. So negotiation skills again depend agreement to agreement. You cannot use the same negotiation skills everywhere. It depends on what exactly your client needs, what are the rights that he has according to the law. Okay, now you're the lawyer, he must focus on if you are on behalf of the licensor, you must focus on the following points. One is brand protection and goodwill. Every clause must talk about how you can protect the goodwill of the brand. Quality control, we just spoke about why we need quality control, how you can maximize the royalty. You need to ensure that there are sufficient clauses which will prevent the uh, misuse of your IP. You will also have to limit the physical territory, and there should be a quick termination clause. Termination clause which is effective on the condition of breach of any of the terms and conditions. Now, if you are a lawyer on behalf of the license, so what are you going to negotiate? What are the points that you are going to focus on? You will focus on how you get the maximum usage rights, how you can lower your royalty rates. I know both the slides are contradictory, but then when you are answering on behalf of the, what do you say, behalf of the licensor, you will have to use, your perspective is different. So the justice that your client has to get will also be different. You will have to get the license agreement for the maximum duration. Now, most of the times, the license agreement are valid for 3 to 5 years. The reason they are given for 3 to 5 years is because any business takes around 1 year to settle down, to raise the awareness. You can only exploit a business or so the reason why you need a longer duration for the license clauses, because one, it takes around 1 to 2 years to establish your business, to spread the awareness. Only from years 2 to 5 is when you will actually start generating revenue. And in the middle of all this, if you have to renew your license agreement, it is going to not only delay your procedure, it's an unnecessary hurdle that you're bringing. Okay, so try to have it for longer duration, at least for 5 years. You need to have your renewal rights. You need to have flexibility in marketing. That is, in what are the ways you can market, where all can you keep using this logo. Then about sublet licensing rights, that also depends on whether you want to sublet or not. Now, do you need to register a license agreement? It is something that's not advisable. It's advisable, but it's not something that's mandatory. So you will register it with the registrar of trademarks and not with your office of subdivisional registrar. You will have to fill in form TMU. Now, and the charges are around 15 to 20,000. That is what I had found out last. The benefits are, of course, you get a legal recognition. You get a right to sue if you are a registered user. And the registered licensee also gets certain rights for statutory enforcement. Now, let's talk about why the whole clause of quality control was so important. It is something that's mandatory under the trademark law. If you fail to have, the quality control, it may lead to loss of distinctiveness. You are a brand which is existing in the market, and it's only because of your certain quality that people know about. If your franchise doesn't have the products as per that quality, then that can become a huge issue. Because remember, goodwill of a brand is also a trademark. So when you are giving, when you enter into a license agreement, you are also you're also renting out your goodwill. Your trademark becomes invalid, and your license must also ensure that there is limited controlled use of the mark. One basic question a lot of students have in their mind, that is, what is the difference between assignment and license? So in assignment, again, ownership is transferred. It is more permanent and full rights are transferred. License is temporary, limited rights, and you have to pay a royalty. These are some case laws that I had. So Quality Chef Agro Food Private Limited versus ADF Trading Private Limited. So this talks about how licensing, it does not affect ownership rights. And the distinction between assignment and license is also clarified in the same. Then you have Hyundai Motor Limited case. So royalty structure and licensing agreement was recognized in this particular case. Delhi High Court has a judgment on permitted user agreement. Permitted user, he cannot independently sue. Only registered or proprietor users can sue for trademark infringement. So here are a few drafting tips. Okay, you need to always define your scope clearly. You have to avoid ambiguity, especially in these clauses. What is the territory? What are the products and services that you're going to offer? What is which action or inaction is going to lead to termination. You need to ensure the compliance with trademark law, and you need to mention the documentation of your usage. That is, am I going to use the logo in my billboard? Am I going to use it on my social media? Am I going to use it for posters, for promotions, etc.? So this was in short with respect to the trademark licensing agreement. Now let's move further on. How can we exactly draft an agreement? So just give me a minute. If you have any queries, you can drop it in the chat box. Hope it's visible. I'll try to increase the screen. This one has increased. So this is a rough agreement that I have between a burger unit and a private limited company which is opening a franchise. So when you open a franchise, you enter into a franchise agreement, and your franchise agreement will have another sub agreement or another agreement along with that you will enter is your trademark licensing agreement. So your trademark licensing agreement again. So this is going to be your date. This is your parties, who are the names of the parties, etc. Again, as both are private limited companies, you will have your board resolutions, which will authorize the personnel from the company to enter into this agreement. So you will have that licensor and licensee shall be hereinafter referred to as partners, parties, etc. Now, this is your main recital. Wherever you have whereas, it is the recital clause wherein you will mention the intention of agreeing, entering into the agreement, and who are the parties and why are they entering into the agreement. So here you will talk about that the licensor, that is Burger Gourmet Burger Company, along with its associated logo, trade dress, brand elements, goodwill, are duly registered. They are a well-known chain of burger restaurants in India. The licensee has approached to request a license to use the trademark at their franchise, and the licensor has granted limited, non-transferable, conditional license to the licensee. There are certain conditions which are laid down. Okay, now comes the grant of license. Here, the licensor has granted a limited, it's a non-exclusive, non-transferable, revocable license. Your license will always be revocable. You cannot keep it irrevocable. Okay, and where can you use it? Only at this particular licensed premises, nowhere else. The license, it does not confer any ownership of trademarks upon the license. Now you will mention the territory, that it is only for this particular outlet. You will have to mention the detailed address of the outlet wherein you can use it. and you cannot use it anywhere else without a prior consent. For example, let's say it's a burger joint. Okay, they have their main outlet in one place, and let's say their storeroom or their workshop where they cook the food in bulk is at a different place. Your trademark agreement license says that only at this particular premises, that is where your main shop is, you can use the logo and trade dress and whatever it is. So you will not be able to use it in your another shop, which is also a part of this outlet itself. It is your working kitchen or your extension. You will not be able to use the logo over there. So that's why you must have seen that a lot of big outlets, okay, they will have their kitchen somewhere else, but you won't find their logo. You won't find any details about whom this belongs to. So this is the main reason. Then this agreement is for 5 years from the date of execution. Okay. Now comes the most important point, consideration and liability. Now licensee, he will pay a one-time fee, okay, and a royalty equal to, that is, if they earn a revenue of 100 rupees, around 5 rupees will be given. Again, this is a clause which is completely negotiated. How good are you with negotiations is what will decide the amount. Royalty is anywhere between 2 to 5%. Nobody goes about 10%. It's a very bad deal if you anytime go for royalty about 10%. It's a suicide, to be honest. Then comes your quality control. So you will talk about how you will adhere. The licensee has to adhere to the quality standards. There has to be recipes, branding guidelines, operational procedures. Everything has to be approved by the licensor. The licensor can also inspect the premises to ensure compliance, and the licensee, he acknowledges that maintaining quality is something that's very essential to preserve the goodwill associated with the trademarks. You will also talk about where and how this trademark can be used. You will not alter it, modify it. You will not misuse it. It will be used only at those certain places. So if you go to a McDonald's or you go to a burger joint, you see their interior is done in a certain way. All the outlets of McDonald's will have their interiors done in the same way. All the outlets of Burger King has their interior done in the same way. Why? Because that is what creates the distinction. You go to a Pizza Hut, you will not find any you will not find any kitchen that is clearly visible. Okay, so my laptop battery is quite low. Just give me a couple of minutes, I'll be back. Yeah, I'm back. The next clause that we have is with respect to the ownership, that is, who owns the rights. So, of course, as we discussed earlier, it's the licensor who is the proper owner, and the licensee doesn't have any rights. Then there is no sub-licensing that is permitted under this agreement. All the information that will be shared, that is your recipe, the business model, your packaging details, all the confidentiality will be maintained by the licensor and the licensee. It will not be shared. You can also enter into a separate confidentiality agreement. Usually, before you enter into any agreement, you enter into an NDA, which also covers your confidentiality clause. If you want to know how to draft an NDA, there is already a session which is pre-uploaded. You can check on the YouTube channel, you will come across. So your confidential clause can be expanded and protected into a separate NDA. You also have your indemnity. Indemnity is very important in this case because when you are granting your trademark use license, you are also loaning them your goodwill. Goodwill is something that an individual builds across years. It is not built overnight. So you need that indemnity from your licensee. Again, termination, you will mention whether it is non-payment of royalty, if there is no failure, if there are repeated complaints, you will mention your heads. If these clauses are not followed, then there will be termination. What happens after the termination? You will disclose, you will discontinue the usage of all the trademarks, remove all the signage, branding, materials associated with the licensor. Now the licensee will not represent itself as being associated with the licensor. Then comes your standard boilerplate clauses of governing law and jurisdiction, dispute resolution, force majeure, entire agreement, etc. Okay, so you will have even your notice, that will be the clause for notice where the legal notice will be sent. So this is in short on how you are going to enter into a legal agreement for trademark licensing. We have already completed a few drafting sessions. You can check the previous videos. So thank you so much, and do subscribe to the channel to stay more updated with respect to drafting.